We're back in session in cause number 324160. Let the record reflect that the jury is present in the courtroom. We have the defendant, Mr. Cleavon Demetrius Buxton, that's present with his attorney, Mr. Corey Crenshaw, and we also have present Mr. Jansen Bailey. For the state, we have present Ms. Julie Maxey, and we have present Mr. Raymond Shearer. We will proceed at this time with the trial in this case. Ladies and gentlemen of the jury, I have before me a document that is called the charge. And ladies and gentlemen of the jury, I will read this charge to you. Charge of the court. Members of the jury. The defendant, Cleavon Demetrius Buxton, stands charged by information with the offense of being intoxicated while operating a motor vehicle in a public place, and the analysis of a specimen of the defendant's blood showed an alcohol concentration level of 0.15 or more at the time the analysis was performed. The offense is alleged to have occurred on or about the 29th day of June of 2019 in Jefferson County, Texas. The defendant has entered a plea of not guilty. Our law provides that a person commits an offense if the person is intoxicated while operating a motor vehicle in a public place. A person is deemed to be intoxicated within the meaning of the law when such person does not have the normal use of physical or mental faculties by reason of introduction of alcohol, a controlled substance, a drug, a dangerous drug, or a combination of at least two of these substances into the body. The term intoxicated also means having an alcohol concentration of 0.08 or more. A public place means any place to which the public or a substantial group of the public has access and includes, but is not limited to, streets, highways, and the common area of schools, hospitals, apartment houses, office buildings, transport facilities, and shops. Alcohol concentration means the number of grams of alcohol per 210 liters of breath, 100 milliliters of blood, or 67 milliliters of urine. Now, bearing in mind the foregoing instructions, if you unanimously find from the evidence beyond a reasonable doubt that on or about the 29th day of June 2019 in Jefferson County, Texas, the defendant, Cleavon Demetrius Buxton, did operate a motor vehicle in a public place while said defendant was intoxicated, and that the analysis of a specimen of the defendant's blood showed an alcohol concentration level of 0.15 or more at the time of the analysis was performed, then you will find the defendant guilty as charged. Unless you do so find beyond a reasonable doubt, or you have a reasonable doubt thereof, you must find the defendant not guilty. General instructions. All persons are presumed to be innocent, and no person may be convicted of an offense unless each element of the offense is proven beyond a reasonable doubt. The fact that a person has been arrested, confined, or indicted for or otherwise charged with the offense gives rise to no inference of guilt at the trial. The law does not require a defendant to prove innocence or produce any evidence at all. The presumption of innocence alone is sufficient to acquit the defendant unless the jurors are satisfied beyond a reasonable doubt of the defendant's guilt after careful and impartial consideration of all the evidence in the case. The prosecution has the burden of proving the defendant guilty, and it must do so by proving each and every element of the offense charged beyond a reasonable doubt. And if it fails to do so, you must acquit the defendant. It is not required that the prosecution prove guilt beyond all possible doubt. It is required that the prosecution's proof excludes all reasonable doubt concerning the defendant's guilt. You have a right to consider all of the facts that are shown by the evidence and to draw natural and reasonable inferences from such facts. You alone have the authority and duty to determine what the facts are. In evaluating the evidence, you must totally disregard what you believe is my opinion about any factual matter. You cannot question the bailiff concerning the testimony of the law, nor should you discuss the case in his presence. If any question develops during your deliberation, it must be reduced to writing, signed by your foreperson, and given to the bailiff. The question will then be answered by the court as soon as possible to the extent allowed by law. Questions and comments of the attorneys do not constitute testimony and must not be considered as evidence. You must also disregard any statement of the attorneys that is inconsistent with the law contained in this charge. Any physical exhibits admitted into evidence will be furnished to you by the bailiff upon your request. You must not consider facts that have not been introduced into evidence or legal principles not contained in this charge. It is improper for you to discuss or consider anything which you know or have learned outside of the testimony presented to you and the law contained in this charge. If you should discover that you have any outside information, you should not mention this information to any other juror, nor consider it yourself in arriving at a verdict. Our law provides that a defendant may testify on their own behalf if he elects to do so. This, however, is a privilege accorded to a defendant, and in the event he elects not to testify, that fact cannot be taken as a circumstance against him. In this case, the defendant has elected not to testify. and you are instructed that you cannot and must not refer or allude to that fact throughout your deliberation or take it into consideration for any purpose whatsoever as a circumstance against the defendant. You are the exclusive judges of the facts proven, the believability of the witnesses, and the weight to be given their testimony. However, you must be bound by and strictly follow the law contained in this charge. Your failure to follow the law could result in a mistrial being declared, and your deliberate violation of this charge could subject you to being held in contempt of court. After the attorneys present their arguments, you will retire, select a foreperson, and consider your verdict. The arguments are not evidence, and you should give the arguments only the consideration you feel they deserve during the evaluation of the evidence. It is the duty of your foreperson to make certain that your deliberation are conducted in accordance with this charge. After you have reached a unanimous decision, your foreperson should sign the appropriate verdict attached to the charge. In returning your verdict, it is your responsibility to make certain that justice is done in this case. The last page of the charge is the verdict page. If your decision is we, the jury, find the defendant not guilty, then the foreperson will sign the top line. If your verdict is we, the jury, find the defendant guilty of driving while intoxicated and blood showed an alcohol concentration level of 0.15 or more at the time the analysis was performed, then the foreperson will sign on the bottom line. Do we understand? Okay. Okay. At this time, we will have our closing argument. State you have a right to open and close. State.
The state waives opening, Your Honor.
Okay. Mr. Crenshaw, you may proceed, and each side will be given 20 minutes.
Thank you, Your Honor. Well, first of all, let me thank you for your patience. I know this has not been an easy process. You all have the pleasure of serving as the jury on the longest DWI trial in the history of the state of Texas. We've been here over a month, and usually it's only in California that you see trials that seem to never end and go on forever. Anyway, thank you all very much for your patience, and please understand that the ridiculous break that we had there in the middle was completely out of our control. But we do appreciate the judge and being cautious and making sure that everyone is safe and healthy for this process to continue. Normally, I do not spend a lot of time going through the testimony, but because it has been a month and 3 days since we were last here to hear the testimony from the state's witnesses, I have highlighted some portions of testimony that I would like to refresh your memory with. And before we go through this, I want you all to think about exactly what we started this trial with in Board I. The burden of proof in this case is on the state. The state does the accusing and they do the proving. Each of you individually must be satisfied beyond a reasonable doubt of each and every element. The good news is the only element that we are disputing, ladies and gentlemen, is did Cleavon Buxton on June 29th, 2019, drive or operate that motor vehicle? And I submit to you that the state has failed to prove to you beyond a doubt that's reasonable that he in fact was driving. Let's now go through the state's very first witness's testimony, Sergeant Verdine. He starts off early on in his testimony. My question, are you testifying today to tell the jury that my client was operating the vehicle before you got to the scene or after you got to the scene? His answer, before I got to the scene. Then I asked him a further question and he offers a little bit more explanation. He says, a reasonable and prudent person would believe that the person that's in the driver's seat of that vehicle had just prior operated to that position on the roadway. Again, Sergeant Verdine wants you here on the jury to believe that just because Cleavon is in the driver's seat, that he must have been the one that drove that vehicle to exactly where we found it that night in the middle of the roadway. And Miss Maxey, on direct examination, doubles down on that idea. She asked the question, did the defendant ever say that he pushed the vehicle there? No. Did he run like the Flintstones? I would assume not. The state's case was based completely upon this assumption that Cleavon was in fact the driver of that vehicle that drove to the point where we found it. And again, you get more from Sergeant Verdine. He says, I mean, if he got there talking about the vehicle there in the middle of the roadway. So you just because you fall asleep behind the wheel of a vehicle does not deteriorate the fact that you were operating that motor vehicle. He assumes and wants you to assume that Cleavon was driving that night and just happened to fall asleep behind the wheel, which is where they found him at 4:30 in the morning. And then again, he says later on, I mean, if he had got there, he had to have. Again, talking about him driving that vehicle to where they found the roadway. Someone had to have driven that vehicle with him behind the driver's seat. And then he tells you in his own words what he wants you all to assume and believe. I asked the question. So you just assumed he's the one that brought the vehicle here. And you just assumed because he was behind the wheel that he was the original driver. And you now want to make him guilty of the offense because of that assumption. Yeah, that's pretty much what we need. I mean, you know, a guy behind the wheel. But then at the very end of Sergeant Verdine's testimony, after I had basically done everything I could to show that they were going to have no proof whatsoever that my client was the one that actually drove the vehicle that night or operated the vehicle to the point where the deputies found in the middle of the road, he finally realizes the error in their case and flips. By me, your testimony to this jury is my client was operating the vehicle before or after you arrived at the scene. Now he changes his story and says after, because they know now they can't ever prove to you that he's the one that drove the vehicle there that night because he didn't, his brother did. And so now they want to go with this ridiculous theory that you all should find him guilty of DWI because he was asleep in the car and they woke him up. And I say, so your testimony is he was operating the vehicle while he was asleep or after you woke him up? And Sergeant Verdine tells you both. Then we hear from Lieutenant Bailey, a more experienced officer, higher rank, has been a police officer since 1995. We start out with him with the same type of questions. And so I guess I'll go back to my original question. Is your testimony here today that my client was operating the vehicle before you got to the scene or after? And he tells you what we would expect him to say. After or before, he says before. And so you don't have any evidence at all that my client was driving or operating that Cadillac that night before you got to the scene. He answers, before I got to the scene, that is correct? No. You're just assuming, and you want the jury to assume he was the driver. And he responds, yes. But then, if you'll recall, Sergeant Burdine is the one that tried to insert this ridiculous theory that my client was somehow operating while asleep and after they woke him up. But Lieutenant Bailey completely discounts that. My question, either way, sleeping, passed out, is it your testimony here today that my client was operating the vehicle while he was passed out, sleeping unconscious, or after you woke him up? Answer from Lieutenant Bailey, well, even after we woke him up, he wasn't operating. He was sitting behind the steering wheel. And ladies and gentlemen, that's exactly what we got here. And the law in Texas is not, if you sit behind a steering wheel, you're DWI. That's not the law. My question, just please tell these 6 ladies and gentlemen, was he operating that vehicle while he was asleep, passed out, unconscious, or after you woke him up? Which one? His answer, was he operating actively? No. I brought you 3 witnesses here today that told you what really happened that night. And the state, in their cross-examination of those 3 witnesses, acted like this was some ridiculous theory we just pulled out of our hat here at the last minute and tried to insinuate that my client's brother, his friend Justin, and his girlfriend all concocted this story with you all here today, and that the police never knew anything about this theory, that it was his brother that night who unfortunately was driving that vehicle. Miss Maxey's own question, did the defendant ever say who was driving the vehicle? Did he ever say it was someone other than himself? Lieutenant Bailey says, I can't recall directly right offhand without looking at my report. She then says, did he ever mention how the car got to the middle of Old Sour Lake Road in the middle of the night? Again, if I can look at my report real quick, something was said. He looks at his report and he then answers, I remember him saying something about his brother. And why did Cleavon, in his drunken stupor that night, say it was his brother? Ladies and gentlemen, because it unfortunately was his brother. But like 2 brothers would do when confronted by the police while intoxicated in the middle of the night, having just been woken up after being asleep there in that car for over an hour. They didn't want to rat each other out. And we're not on trial here today because I'm proud of what my client did that night. I'm the first to tell you, he had way too much to drink. His brother had way too much to drink. Neither one of them had any business ever driving that night. But your job here today is not to say whether my client made a mistake that night. Ladies and gentlemen, he did. We expect our officers to be better than what we saw in that video. We expect our officers to not put themselves in those types of situations. But your job here today is not to decide that my client was behaving poorly that night. The state does the accusing and the state does the proving. They have to prove to you that it was my client that night that operated that vehicle to the point where it was there in the middle of that road. And ladies and gentlemen, it just doesn't have the evidence Because it wasn't him. It was his brother. They arrested his brother that night for PI. I wish in hindsight they would have arrested them both for PI. But they decided to go with a higher charge. They decided to go with a more significant charge. And we're here today because of that decision. And Miss Maxey is a wonderful prosecutor. This is her first trial. She did a lot better in her first trial than I did in mine. I can't imagine having a month-long break in the middle of my first trial. But your verdict of not guilty, ladies and gentlemen, does not say that Miss Maxey is a poor lawyer. It says that the police that night jumped to conclusions, made assumptions that Cleavon is the one that drove the car, and they did nothing. You heard from Sergeant Verdine. I asked him, what investigation did you do in this case after the fact? Why didn't you subpoena the cell phone records? Why didn't you subpoena which bars they were at? Why didn't you do anything? Why didn't you go and look for anything? They did nothing. And they left Miss Maxey with a very weak case. It's not her fault. And it's not your fault either. Sometimes when people are talking about DWI, they're worried that their verdict of not guilty sends the wrong message. And like you're approving people to go out there and drive drunk. Ladies and gentlemen, that's not what your verdict does here. Your verdict of not guilty sends the message to our law enforcement that if you're going to arrest someone for driving while intoxicated, you better be sure you get the right person. What else does your verdict do if you were to find my client guilty? While I'm not happy about what my client did that night and said that night on the video and how he acted, I am proud of him for not driving. He certainly could have. You have the cell records. He called his girlfriend and said, "Come get us." He tried to make the right decision. And if your verdict here is guilty, it sends absolutely the wrong message. That's not what we want people to do. We want people in their drunken stupor not to drive. And if you're going to be asleep in the car for an hour while you're waiting on a sober driver to come pick you up, and you're still going to go to jail for DWI, that sends absolutely the wrong message. We want people not to drive. We want people to sleep it off in their vehicle. Now, would we have preferred Alton not to park it in the middle of the road? Yes, but unfortunately, that's what we were left with. I know I've been up here lecturing you all, and I apologize about that. I get sort of into it.
Mr. Crenshaw, you have 5 more minutes.
Great, Your Honor. I won't even take that 5 minutes. Ladies and gentlemen, the burden here that the state had that we talked about, we went all the way up that line from reasonable suspicion all the way up to the top burden in our land. And the law does not allow us to define what beyond a reasonable doubt is. But you all know. Was there enough that night to arrest my client for DWI? Well, maybe, because the police get to make assumptions. But you all don't. You all took an oath that your verdict would be based upon facts and evidence and not assumptions. The fact that night was that my client was woken up after he had been asleep for over an hour. As you all might imagine, after you've been drinking a lot and you've been asleep for an hour, your mind is not going to be that great. And he had a nightmare happen to him. He went to jail for a charge that he was not and is not guilty of. And your verdict here today, ladies and gentlemen, if you were to find him guilty, sends absolutely the wrong message. It allows the police to show up on a scene, make assumptions for whatever it is they think must have happened before they got there, and haul someone off to jail and destroy their life and their career. When you go back in the room, please ask yourself, knowing what you know now, knowing now that it was not him driving that night, knowing now that he was trying to get his girlfriend to come out in the middle of Sour Lake Road and find them that night to get them home safely. Ladies and gentlemen, I ask that you reach the only conclusion that would be just in this case, and that is a verdict of not guilty. Thank you.
Ms. Maxey, you may proceed.
Thank you. I'm going to switch out the PowerPoint.
Okay.
Also get exhibit number 1, Your Honor.
Yes.
Ladies and gentlemen, thank you for your patience during this time. Thank you for being willing to show back up. We couldn't do this without you. You're an integral part of seeing that justice is done today. And so I really, truly thank you. You know, the good news about being a part of the longest DWI trial in Jefferson County is that we've been gone just enough time for you to forget everything that was testified to. So if you don't mind, I'm going to go back through a couple things that we went over. Of course, this is the DWI trial. And you'll remember in the very beginning, I mentioned to you that there were 3 elements that had to be proven to you for the defendant to be found guilty of DWI. The first one was that the defendant has to be intoxicated while operating a motor vehicle in a public place. I'm going to talk a little bit about each of these elements. So the first one we'll talk about is being intoxicated. And if you remember, at the end of our first day together, we read something into the record, and it was because the defense stipulated to intoxication, meaning everybody here agrees that the defendant was intoxicated that night. You don't even have to decide that for yourself. It's already been agreed upon. His blood alcohol concentration was a 0.23 that night. That's almost 3 times the legal driving limit. Now let's talk about the third element, being in a public place. You'll remember that the vehicle was located on Old Sour Lake Road. During the testimony, there was some time spent on if somebody can get drunk and sit in their driveway in their car as a DWI. Well, remember in this case that this is not a driveway. This is a public road. You'll remember watching the videos that there were cars attempting to pass, multiple cars driving by during all the circumstances that took place. And the last element is that second element, operating a motor vehicle, the hotly contested element. And at this time, I want to play part of Exhibit 1, the video that you watched during Sergeant Burdine's testimony, just to refresh your memory a little bit.
In your hands. And driver, passenger. Let me see your hands. Hey. See both of your hands. Both of your hands right now. Let me see your other hand. Let me see your other hand. Let me see your hand. Let me see your hands. Let me see your right hand. Let me see it. Sheriff's office. Step out slowly. Come towards me. So you're gonna step out right now. Step out. Step out, man. What'd you say? What'd you say? What is your name?
I'm Officer Buxton.
You got an ID on you?
Yeah.
Hey, hold on a minute. You got a gun in your car, buddy? All right. Hey, come out here and get your ID. You got a gun on you right now?
Yeah.
Hold on a second, though.
Buxton, Officer Buxton, and all that shit.
This is one of them?
Yeah.
Can I grab it?
Yeah, yeah.
Everything's recorded.
Yeah. I got it.
Port Arthur PD, not on one. Hey, hey, let's go. All right. Come back. What's your name? You. What's your brother?
You fuck me.
Yeah. See that.
All right, we can turn it around.
Where you trying to go?
We go to the house.
Where's the house?
And mama,
You know where you're at?
yeah, that's where we were.
No, man.
With,
You're on the whole side of Lake Road heading towards China.
well, I was up there, so we were putting outside. I was sick, it broke on my. It's. No, sir. Okay. Yeah, you don't want to do it to the turn for you. Oh, yeah. Good. See, right. I don't like I do not like the, weapons. I don't. The what, the weapons? Yes. I'm gonna put, two of them on. Come on, so. This one, put your hand. Put your hand up. This car key, oh, there it is, the rest of it. Okay. Yeah, that's what you're talking.
Okay, ladies and gentlemen. Now you heard and watched in that video what was going on at the time when the sheriffs arrived. And you heard and you saw that the headlights were on that vehicle, that the brake lights were on, that the motor of that vehicle was humming, that the dashboard was lit up, and you saw the defendant in the driver's seat of a running vehicle. Now let's talk a little bit about that second video. The key fob for that car was in the pocket of the defendant. What about the officer's testimony? That's what Mr. Crenshaw focused a lot on. Let's talk a little bit about that. You had the first officer, Sergeant Verdine, the arresting officer, that testified that the vehicle was running when they approached, that the defendant was sitting in the driver's seat, that the brake lights were on, that there was exhaust smoke coming out of the muffler, and that he heard for himself the engine running. What about Lieutenant Bailey? He was the second officer that we heard from, the accompanying officer in this case, and he also heard the motor running, didn't he? The headlights of the vehicle were on, and he saw the defendant seated behind the steering wheel of a running vehicle, which was parked in the middle of the road. So ladies and gentlemen, if at that point, Mr. Buxton wasn't operating the vehicle, who was? The defense would like to focus on the car. They want you to believe that it has to be in driving down the road for the person to be guilty of driving while intoxicated. And that's just simply not true. They also want you to feel like he was just magically sitting behind the steering wheel of a car and nothing else was going on. The car was running, the car was on, the car was functioning, and someone was operating that vehicle. Now, if I want to go downstairs to my car down in the parking lot, I can't just throw my car into drive, can I? There's a lot that goes into it before I can actually get to drive. I have to have the key. I have to get into the driver's seat. I have to start the ignition. I have to have access to the pedals and the steering wheel and the gear shift. All of that happens before I can even put the car into drive. And all of that is part of operating a motor vehicle. And this is not Transformers. This is not a Michael Bay directed film. Cars don't operate themselves. Someone was operating that vehicle. Now we heard from the friend, Mr. Richardson, who didn't have any actual evidence that someone else was operating the vehicle that night, did he? And then we also heard from the girlfriend, who also didn't have any actual evidence that somebody else was operating the vehicle. And we heard from the brother. The brother who you might remember admitted on stand to lie to the police. The one who clearly remembers a whole lot except how much he had to drink, that gets fuzzy. And couldn't remember where the key was, that part was fuzzy, but the parts he needed to remember, he sure could. There's really no other evidence, direct or circumstantial, that anybody else was operating that vehicle. But there is a lot of circumstantial evidence that points to the defendant as the operator of that vehicle. You said you would need facts to make an informed decision as jurors in this case. So here's what we know. We know that we have a Port Arthur police officer, someone who is sworn to uphold and enforce the law, passed out behind the wheel of a running vehicle with the lights on, with the motor running, with the exhaust emitting from the car, parked in the middle of the road, with multiple cars attempting to pass throughout.
Objection, Your Honor, that's a misstatement of the evidence. There was one vehicle that tried to pass about 30 minutes after the police arrived.
Okay, ladies and gentlemen of the jury, questions and comments of the attorneys do not constitute testimony and must not be considered as evidence. You must also disregard any statement of the attorneys that is inconsistent with the law contained in this charge. The arguments are not evidence, and you should give the arguments only the consideration you feel they deserve during the evaluation of the case. Ms. Maxey, you may proceed.
Thank you, Your Honor. There's really no actual evidence that points to anyone else. See, we did have the brother, right, that his story didn't exactly line up. He said in the video that they were driving around talking about his mental issues. But today,
Ms. Maxey, you have 5 more minutes.
thank you, Your Honor. But today, there was construction, so they just had to take that way and they were going straight home. The one that lied to the police, the one that took a 20-minute phone call, pulled over in the middle of the road, and then passed out. So if I'm going to ask you who is operating a motor vehicle, is the person with the key or the person without the key? What about who's operating the motor vehicle? The person in the driver's seat or the person in the passenger seat? Who's operating the motor vehicle? Is it the person who has access to the pedals and the gear shift and the steering wheel and the ignition? Or is it the person who doesn't have access to any of those things? Mr. Crenshaw wanted to determine if they were operating the vehicle before or after the sheriff's arrived. Now, if you believe it was after, then, they had the car running with the defendant in the front seat, in the driver's seat. You could reasonably believe that he was operating the vehicle after, or you might believe that he was operating it before. The car didn't get there on its own. It wasn't dropped from a helicopter like it was in Fast and Furious. It wasn't towed there. It wasn't pushed there. It was driven there. And there's really no other evidence that points to anyone else. Well, if our choices are he was operating the vehicle before or he was operating the vehicle after, well, guess what? Either way, he was operating the vehicle. So if 3 of you believe it was before and 3 of you believe it was after, then 3 of you believe he's guilty and the other 3 of you believe he's guilty. Either way. Let's use our common sense. Beyond a reasonable doubt does not mean you check your common sense at the door. There's no evidence really of an alternative here. On June 29th, 2019, in Jefferson County, Texas, the defendant was intoxicated while operating a motor vehicle in a public place. And the state asks that you return a verdict of guilty. Thank you very much, ladies and gentlemen.
Ladies and gentlemen of the jury, at this time, all the evidence, the court's charge, and the closing argument of counsel are before you. I'm going to hand the bailiff the charge together with the verdict form. They will be left with you as you deliberate. Actually, the deliberation is going to take place in the courtroom because of our COVID protocols. And no one will be in here but you. And obviously, if you have any questions, you can direct them to the bailiff. And you will also have access to the restroom as well as the coffee area. Once all of the members of the jury are present and assembled, the case is formally submitted to you and you may begin your deliberation. So at this time, we're going to ask counsel, make sure that you take all of your materials, your briefcases, and everything with you, and we're going to leave the jury room, we'll leave the courtroom, and this will be used as the jury room.
Judge, during deliberations, will we be turning off YouTube?
Yes,
Oh, good.
in fact, YouTube is being turned off as we speak.
Okay, just making sure.